Yeah, we really had it. Yeah.
Do you remember there's a meeting?
You said I'm coming.
Are you kidding me? You're not kidding.
He's not coming.
Shocking. I mean, pretty good reason.
You said he's not coming.
That's what it is.
Right.
Couple of minutes yet. What?
Mr. Bachman's not coming? Did you
No.
know that?
No idea. It's up to him.
Yeah.
Okay.
Okay, we'll call this hearing to order. Meeting of the Board of Zoning Appeals on Tuesday, August the 12th, 2025 at 6 p.m. Can we hear the roll call?
Dean?
Here.
Davis?
Here.
Paul?
Here.
Costanus? Here. Valentini?
Here. Can we hear a motion to approve the minutes from July 15th, 2025 meeting?
Move.
Larry?
Yes, I'll move. To approve the minutes.
We have a motion on the floor to approve the minutes of the meeting of July 15th. Can I hear a second?
I'll say.
Steve, second?
Dean?
Yes.
Davis?
Yes.
Paul?
Yes.
Costanus?
Yes.
Valentini?
Yes. Okay, we're here tonight to continue the hearing of the appeal filed by Charles Bennett, Erie County Assistant Prosecutor representing the Vermilion Township trustees and Erie County Commissioners, the decision issued by the Vermilion Township Administrator, which nullifies a citation issued by the previous Township Administrator on property located at 12809 Cherry Road, Vermilion, Ohio, 44089. Parcel number 12002000.000. Property is zoned agricultural. Notice of the hearing was published in the Vermilion Photojournal, Vermilion Township website and Vermilion Township Bulletin Board. Written notices were provided to all adjacent property owners within 500 feet. Okay, correspondence, we have a disclosure from Mr. Bennett, of which I am party to. Basically what it is, he says, I make the following disclosure to you as well as the Vermilion Township Board of Zoning Appeals through Board Secretary Lorraine Bailey under R 3.5 of the Ohio Rules of Professional Conduct. On Wednesday, August the 6th, 2025, Vermilion Township Board of Trustees voted to go into executive session during its regular public meeting. Those present were Ken Bauman, Kurt Johnson, Don Rowe, Ken Bilancini, Charles Bennett. Item of discussion, whether the board joined as an interested and active party. Mr. Bennett's appeal of Mr. Joe Baxter's zoning certificate of compliance issued to Robert and Jessica Dunn. Issue 1, Mr. Bilancini is the chair of the BZA. Hearing the appeal, having him join the executive session could potentially be viewed as an ex parte communication with the chair in violation of R 3.5 A3I. I immediately objected to his presence in light of the issue. Issue 2, as an officer of the court of Ohio, I can assure you that no attempt was made to sway or influence Mr. Bilancini's view of the case under ORCP 3.5A1. The discussion was solely limited to whether the board joined the appeal. Issue 3, I am unable to discuss any additional specifics of the executive session under the attorney-client privilege. Ohio revised ORCP 1.6A. Going forward, I will not object to your questioning Mr. Bilancini on the record to determine if he may have an influence. I will not challenge my objection to his ability to continue in the case. Okay, I was there. I was told to attend the trustees meeting, at which time a motion was made to go into executive session, which my name was included. I had no idea what was to transpire, so I went and sat into the meeting. Mr. Rowe took the floor, and he was concerned about the Sunshine Law. He was concerned about our questioning of the trustees concerning why they were there, and as far as were they appellants or were they there just to support, how do they put it, as an interested and active party. My questioning referred to them as appellants during the last meeting. Basically, that was it. Immediately, Mr. Bennett, did bring up the fact that he shouldn't be there or I shouldn't be there, which, and I was in total agreement. The meeting ended by my telling the trustees simply that I cannot relay any of their message to the board. If they want a message to the board, that they should write a letter to the board, our board here, explaining what they were trying to get across to me, and then I left. So I don't feel I was influenced in any way, shape, or form. I didn't discuss anything with Mr. Bennett. I don't think that I should have been called into an executive session in the first place. But, as I'm not an employee, but as a volunteer, and the trustees ask you to do something, most of the time you would do it. So, Mr. O'Toole, do you have any questions?
No questions and no objections. I really don't see any kind of conflict, so we're perfectly happy with you saying as chair.
Thank you very much. Okay, that's out of the way. But I do appreciate, Mr. Bennett, your disclosure. I appreciate that.
Thank you.
Okay, now Mr. Bennett also supplied us with his rebuttal to the letter that we had last week. And Mr. Bennett, would you like to go through your your rebuttal.
I'm gonna be real brief,
Yeah,
Your Honor, and we appreciate this.
one other thing, if, now, as an officer of the court, you will not be sworn in. Anyone that was sworn in to speak last week is still under oath. And we're not gonna re-oath anybody, so to speak, okay? Please.
The Duns raised a couple issues in their motion to dismiss. The first one was whether we timely appeal within the 20 days of Mr. Baxter's citation. He issued that citation on one of three dates. It was either 5/16 of 25, which is the scheduled date and completion date. There's also an activity date on there of 5/19 of 25. We've heard no testimony as to when the time would have started tolling against us, and there's really no way to tell from the document itself. Okay? In any case, we did not hear about Mr. Baxter's certificate until 5/29, which is either 14 days after the 5/16 date or 13 days after the 5/16 date. And there was no time when I heard finally that there was this thing out there. I knew that we had a 20-day situation. And I also knew that the Board of Trustees wasn't going to go into a meeting within the time frame. So I contacted Trustee Bogman and said, I've got a bit of a situation. I'm going to go ahead and appeal, both on my behalf, on your behalf, the Board of Trustees, and also on the Board of Commissioners of Erie County, who's the main plaintiff in the case. We then went into an executive session, I think on June 6th, and they agreed through the document you read, the minutes you read last week, that they agreed to be both an interested and active party. Okay. Part of the session we had the other night with you, sir, was what the understanding of what that is. I believe some of the trustees are here to maybe clear that up. Okay. But the main thing I want to say is that when I found out about this on 5/29, I did an appeal on 5/30 on behalf of myself and both boards, and that should count. Mr. Baxter later got back to me and said, well, we really need a cover sheet on that, and we got you a cover sheet on June 6th. Okay. That is well within the 20 days of me finding out about this. So I'm asking the board simply to find out of fairness and constitutional notice provisions that we appealed in good faith and within a timely manner. The next thing that the Duns have raised is whether or not we have standing. And standing is an interesting thing in the law. In this zoning appeal, typically what this board will hear is someone seeks a variance to turn maybe their house into a B&B, or someone seeks a variance to add an addition onto their home, maybe a little too close to the road, etc. And what the board does is they get hold of everyone within 500 feet of the property so that people can come in and be heard. We're dealing with that all over the county in various forms in front of other boards of zoning appeals. This is a little bit different because what your document says, or what your zoning code says at 4.10, is appeals to the Board of Zoning Appeals may be taken by any person aggrieved. And the question is, who is aggrieved here? Well, first of all, I represent both the Board of Trustees and the Board of Commissioners. We have a document, and this is what I explained a couple weeks ago, and so I'm not going to go back into it, but we have a document from Keith Sexton that has been upheld in this case. So I'm aggrieved because now suddenly there's a new document from Mr. Baxter, and when we go back before Judge McMonigal, he's going to say, Mr. Bennett, which of these controls here? Mr. Sexton says that there's a violation. Mr. Baxter says any violation has been cured. What's the status? And I want this board to merely say, we're not here to debate the merits of whether or not the agricultural exception applies to the case as a defense to the Keith Sexton citation. We're only here to recognize that where the trial court, Judge Roger Bennett says, I am going to enforce the citation. And Mr. Dunn appeals, and the Sixth Circuit says, or I'm sorry, the Sixth District Court in Toledo says, I affirm that decision. That is the law of this case. It cannot be brought back for additional argument. And I just want this board to recognize that without getting into whether the ag exception applies, without getting into whether Mr. Dunn is actually using the property right now for agriculture, such that any building he's putting, or I'm sorry, any dirt he's filling in, any structure he's building to block water, whether that's incident to current agriculture. We think it isn't because we didn't see any agriculture on the land when we were all there the other day. Those issues are for perhaps the court. This body, I'm really only saying, has to follow what has already been decided in this case by two courts above this board. Now the question is, who else has standing? Well, the issue as to whether the trustees have standing comes down to how were they aggrieved? And the courts look at that and they say, what is your interest in being here? And the Board of Trustees is here to protect Cherry Road, which has repeatedly flooded as the result of the Dunn's makeshift dam. That is what the evidence has shown. We have the engineer of the state of, or I'm sorry, Erie County here ready to confirm that for you this evening. Because I am no engineer, you will need that from a witness. But if they have a statutory duty under 5712 to protect Cherry Road, and Mr. Dunn's behavior is interfering with that duty by pouring 550 tons of dirt into the water course.
Point of information.
I'm
We gotta
talking.
stay on,
Okay.
Chair, we have to stay on task. This is about violation
Let
of the
me,
letter of compliance.
let me determine task, okay?
Well, we're all.
He's giving a rebuttal, so
May I continue?
another outburst, and we're gonna have to ask you to leave.
Okay.
And I'm done in 2 minutes.
Right.
Where they have a statutory duty to protect the road, and that duty has been interfered with, they have standing. That is what the courts have held. That's how a board attains standing in the cases that I cited in my brief. Finally, the Board of County Commissioners, how do they have standing? The AG has said that what Cherry Road is, and a road similar to Cherry, is a connecting road between Darrow and Risden. Where it's a connecting road between two county roads, the culverts on that road are the county's responsibility simply to maintain. And where the water is not flowing freely through that culvert, it exposes the commissioners to a lawsuit from those upstream. In this case, Mr. Matt Lewis. And Matt Lewis has moved to intervene in this case against the Dunns because their land is repeatedly flooded. And most recently, very severely, on July 28th. So for that reason, all of us have standing to be here. And all of us appealed in good faith within the 20 days. And I'm only asking this court for 3 things, and then I'm done. Number one, I'm asking the board to vote that we have timely appealed this certificate because we cannot allow it to be withheld from us for 14 or 15 days. And then suddenly, when I finally do appeal, I'm told that I'm too late. That is not how the Constitution protects citizens who need notice. Notice is part of due process. Number 2, we ask the board to find that we all have standing. And number 3, under the law of the case doctrine, I'm asking you to find that Mr. Baxter's citation is a nullity, because that matter has already been closed. Thank you all.
Thank you, Mr. Bennett. Mr. O'Toole, you have any rebuttal on this?
I do, thank you.
Please. Again, being the officer of the court, it will not be needed to be sworn in.
So for those I didn't have a chance to introduce myself, I'm Dennis O'Toole. I represent Rob and Jessica Dunn. I'm not gonna repeat the arguments that were made during the last session. I want to say I'm respectful of your time. I want to save as much of that time as possible. And quite frankly, I don't know what this case is here. I really don't. So let's go through that if we could in a minute. The zoning administrator for Vermilion Township issued a letter of compliance. It was issued on May the 19th of 2025. I'm assuming all of you have seen that letter.
Yep.
I had it just marked as an exhibit just because I want to put it in for a record. So when I put these-
You have that marked as exhibit,
Number one. I thought it was just easier to do exhibits so that we're not having to spend a lot of time on it.
are you referring to what,
So this is, if I may approach,
yeah, please.
exhibit one is just a compliance letter. Charles, I have a copy.
No, sir, I've seen
Good.
it. I've seen it.
So I just want to put this in context of this case. So this is a compliance letter, and to Mr. Bennett's point, there are a number of dates on here. One of them, the scheduled date of 5/16, and the completion date of 5/16/25 is already on here. I submit to you, and Mr. Dunn will testify to this if you so need, that he received this letter on 5/16. Now, the other important thing, and I want you to do the right thing. So this is the reason why I'm giving you this information. So it's important. If you can get this on your phone. If you type in or put in a Ohio Revised Code section 519.15, 519.15, what does that say? It says that an appeal has to be taken within 20 days of the date of the decision. It says nothing about notices to the opposing party or that has to be published in the newspaper. Read 519.15. It says it has to be, an appeal must be filed within 20 days. Now, I was taught when I was in law school 52 years ago that you either count the first day, you don't count the last, or you don't count the first day and you do count the last. Either way, the appeal time elapsed on June 5th. Either way you count that. Now, why is that important? Because it's a standing principle of law that's been around forever. I mean, think, for example, that there's bids that go out for the construction of a building or a fence or a road or anything else. There's a deadline for the submission of bids. If it says 12 o'clock noon on January the 10th, and somebody comes in at 3 o'clock in the afternoon, they're not even allowed to submit it. It's not a bid. You're too late. The deadline's gone. 519.15 does exactly the same thing. So there was no timely appeal that was done. But let's just, for sake of argument, let's assume that there was a timely appeal. And we'll deal with this issue when we get to some issue of notice, just so that you know. I know you're not lawyers, but let me just tell you something. 14th Amendment, the due process clause of the United States Constitution and the Ohio Constitution has nothing to do with political subdivisions. Political subdivisions are not, they cannot take advantage of the due process clause, the notice provisions of the Ohio Constitution, of the United States Constitution, for anything in their state, because they're a political subdivision. So this argument that they have to get notice and due process and all that good sort of stuff is nonsense. That's a bedrock principle of constitutional law. All right. The second thing is that what happened? Well, the zoning inspector who's hired to do his job reviewed a prior citation. Did he do that in accordance with his duties and authorities? You know, all of you here are subject to whatever the Ohio Revised Code says you can do, and the rules and regulations which you adopt pursuant to them. That's how you operate. You can't give speeding tickets. You can't appropriate property. There's a lot of things that you can't do. What you can do is specifically designed and enumerated by statute. The same thing goes for your zoning inspector. He can't do anything other than what he's authorized to do. What you as a board or township trustees or whoever the legislative authority is. So what are his duties and responsibilities? I'm going to hand you Exhibit 2, which is the job description and responsibilities of the zoning inspector. And if you'd be kind enough to write this down, there are 15 things that are stated there. I direct your attention to the first item, the 6th, the 11th, and the 14th. And let me just read you the very first one. Number 1. Well, it says, the zoning inspector works on behalf of the trustees and shall be responsible to administer and enforce the Vermilion Township zoning resolution. Let me just stop there. Do you understand what that means? What it means is the township trustees have relegated the duties and responsibilities of zoning enforcement and the administration of it to the zoning inspector. They don't have it anymore. He does, whatever it is. The first one says, 1, interpret the meaning and application of the provisions of the township zoning resolution. The third one, which I neglected to put in, says accept, review, process, and issue zoning permits, zoning certificates as provided by the zoning resolution and keep a record of the same. The 6th one, act on applications, notify the applicant in writing of his decisions, no one else, just the applicant. 11, schedule and attend Board of Zoning Appeals and Zoning Commission meetings when necessary. When do you appear? When are you called? When do you have to have a meeting? When there's something that comes before the Board of Zoning Appeals. Well, who determines that? Who schedules that? Usually the township administrator and or the zoning inspector. Last, determine the violation, this is number 14, determine the existence of any violations of the zoning resolution and cause such notifications, revocation notices, stop orders, or tickets to be issued or initiate such other administrative or legal action as needed to address such violations. Well, what did Mr. Baxter do? He's a zoning inspector. He issued a letter of compliance. The end. Which is the reason why I started my remarks. What are we doing here? I'll answer my own question. There was an appeal to the zoning board by the Erie County Commissioners and the Vermilion Township trustees. Okay. You all have enough experience to understand that a board acts through its minutes. That's the only thing you can do. That's why you have Lorraine here. That's why you say, I need a motion. I need a second. Is there any discussion? Let's have a vote. That's how you do things. Mr. Chairman, if you during this meeting says from this point on, we're going to do whatever it is, and that's the end of it, that's nothing. That's not enforceable. It would require a motion and a second and a vote. Some form of a resolution, okay? Ask this question when you deliberate this. What resolution did the Erie County Commissioners adopt to bring this appeal before you? Answer, there is none.
Will object in this basis, Your Honor. There needs not be one. I have had an exec session with them.
May I finish?
He has the floor.
Second, what resolution was adopted by the Vermilion Township trustees in open session, in writing, authorizing the appeal to this board? Answer, there is none. What are we doing here? Thirdly, the other thing I want you to deliberate on, please, is look at Ohio Revised Code Section 519.21A. 519.21A. What does that say? It says there are two types of people that can file an appeal before the Board of Zoning Appeals: an aggrieved party and an official of the township. With all due respect to Mr. Bennett, he is not an official of the township. And the only aggrieved party that would have had standing here would have been Mr. and Mrs. Dunn. That's it. And you know that from your experience. No Tom, Dick, and Harry can come in here before the Board of Zoning Appeals and complain about something that you did with respect to somebody else's property. They have no right to appeal the decision of the zoning administrator. And that, of course, deals with the issue of standing. But let me say that, again, I believe Mr. Bennett, I know Mr. Bennett has misstated what the law is. First of all, the law is very, very, very clear on this. A township cannot file an appeal against its own administrator that they authorize and relegated with the duties assigned to them. You can't do that. The infighting in a political subdivision is not, that does not give you standing to do this. Otherwise, you would have chaos everywhere. And the Erie County Commissioners, they have no more authority over you than you have over them. And remember, there is a pending case in Erie County Common Pleas Court that has nothing to do with what's in front of you. Whether there's a road blocked, or there's a culvert blocked, or there's flooding here and there. We're going to get to those in those pictures that Mr. Bennett provided. But the only people that are standing here would have been an official of the township, an official of the township, of which Mr. Bennett was not, or Mr. and Mrs. Dunn themselves. All right. I beg your indulgence. So, the other sticky wicket is this, and I understand why there's not a lot of time to discuss this, but it's important. How do zoning permits affect agricultural property? And the answer is, it doesn't. It's exempt. So the first argument was well, it's not being used for agricultural purposes. There is even a case cited, Litchfield Township versus there has the winery and the barn where they serve wine, just little to do with this case. Is it being used for agricultural purposes? If I may, and I'm just going to take this in sequence, I'm going to provide you, through the chairman, with Exhibit 3. What is Exhibit 3? Let's go back, and these are in chronological order, and they're important. In chronological order, what you're looking at right now is, entitled, it's Parties Agreement Regarding the Current Agricultural Use Valuation. This was a closing document when Mr. and Mrs. Dunn bought this property. And it says in the second paragraph, and I quote, "The buyer and seller do hereby acknowledge that the property referred to above has qualified for the CAUV exemption under section 571330 of the Ohio Revised Code for the preceding tax year." Now, you all know what CAUV means, current agricultural use valuation. You get a break on your taxes if you're using the property for agricultural purposes. There's a definition of agricultural purposes in the Ohio Revised Code. What does that include? It includes, among other things, not just crop production, but includes forestry and timber maintenance, and things of that nature. That's what Dunn was doing. By way of example, the next exhibit is the Vermilion Township Building Zoning Permit application, Exhibit 4, and attached to that is the permit itself. Why am I showing you this? I'm showing you this because Mr. and Mrs. Dunn wanted to build a barn to hold their agricultural equipment in it. It says right in the application, proposed use, agricultural. Was it approved? It was. A zoning permit was granted. They paid the fee of $242, and that was done on August the 24th, 2021. Next exhibit. Erie County, in there, they're called beacon reports. Exhibit 5, you'll find here again another reference to the Dunn property and the fact that its current use is agriculture. That was in 2024. Next exhibit, Exhibit 6, is a letter from the Erie County Auditor. The letter from the Erie County Auditor, what does it say? Congratulations, you have been approved and or will be staying on the CAUV program. An inspection has been conducted on the parcel listed above, and because it is being used, quote, exclusively for agricultural purposes in accordance with sections 5713, it will be taxed under the CAUV program. Do we need any more evidence that this property was being used for agricultural purposes? Well, I'll tell you what, let me give you one more. And this perhaps most importantly, in exhibit number 7, this is the approval letter from the federal government approving Mr. and Mrs. Dunn's application to be part of what's called an EQIP program. It's a land management erosion control program. It's specifically designed for agricultural property. And if you look through that exhibit, unfortunately, a lot of these pages are not numbered, but in that you'll see continual references to the forestry plan of Mr. and Mrs. Dunn, the agricultural use qualifications which they've already met, There is no question that Mr. and Mrs. Dunn's property is agriculture. And so if you go back to 519.21A, what are you going to find? You're going to find, High Revised Code section that specifically states your zoning regulations do not apply. What are we doing here? And that's exactly what the zoning inspector found. What are we doing? Last, I didn't mark all these. I want to waste your time with this. But you see these photographs that you've gotten here, these guys? Okay, here's a bunch of them. Here's a whole folder full of them. Look at those. There's flooding on Joppa Road. There's flooding at the Vermilion Country Club. There's flooding on darn near every intersection, both in 2023, 2024, and 2025. Is that all Dunn's doing that? Why do you ask this question? Why do you have those? Seriously, why do you have those? It has nothing to do with the issues that's before you. Why do you have those? You have them because this appeal has to appeal to your emotions. You have to say, oh my God, look at what the Dunns have done. Look at this terrible, terrible flooding they've caused. These mean and vicious people. How could they do this? It's nothing to do with what was supposed to be here before this board. And those photographs that I have right there are evidence that there's flooding everywhere. So what's going on here? I view my duty and my responsibility to you, Mr. Hall, to Mr. Dean, to the whole board, all of you, is to help you make the right decision and stop this crazy litigation that's in front of you, because that's where this will obviously lead. This matter should not be before this board. And you have the ability, when you go into executive session to discuss this, to say, look, they didn't file it in time. Done. Or, even if we say that they did file it in time, they're not an aggrieved person or an official of the township. Heck, they didn't even have a resolution adopted that authorized the filing of this thing. And third, there's no requirement that the zoning inspector has to give a notice of his decisions to anyone. And that's not what the statute says, and that's why I pointed it out to you. The law is a funny thing. You have to follow it. You can't make stuff up as you go along. And that's the problem. And that's what's happened here. And I think I'm done. I appreciate your time. I really do.
Mr. Upton, did you want to offer these as an exhibit
Yes,
also?
please. Yes, please.
Do I get a
It's
copy?
8 through 11. They're just photographs.
Okay.
We would like copies of all your exhibits.
Sure, absolutely.
Can you pass all that paperwork back this time? All the exhibit, those marked exhibits. There you go. Thank you, Mr. Upton.
You're welcome. Thank you for your
I'm gonna hold on to this one. I'm gonna hold this one for a
What is
moment.
that one? I can't see
Number-
that. What is it?
Oh, it's,
I've got extra copies.
For approval. Okay. Lorraine, I'm going to give these to you for marking on exhibits. And also, Mr. Dunn, or Mr. Bennett's rebuttal, offer that is an exhibit, let's see where we're at, FG. We could make a lot of money on a paper drive, I can guarantee you that. Let's see. let's just make it exhibit X. Okay? Okay, well, let's take first things first, okay? Question whether this is a legitimate meeting or not. Okay, whether or not the application was on time. We have two pieces of paper. We have one dated May 30th. That is a notice of appeal to Vermilion Township Board of Appeals sent to zoning@vermiliontownship.com. Is that your email?
Yes.
Okay, did you receive this?
Probably. Yeah.
Okay, so,
Yes, I did.
okay, this, does everybody have a copy of that? Pass it. Pass it around. Okay, and on this May 30th, it says that, on behalf of myself, Erie County Board of Commissioners, Board of Trustees, be advised that Charles Bennett and plaintiffs, appellants, and Board of Commissioners, Commissioners et al., Robert and Jessica Dunn, hereby appeal the attached zoning certificate of compliance issued to Robert and Jessica Dunn. We appeal this decision under section 410 of the Vermilion Township Resolution. Then it goes on to say the applicant's appellant shall transmit all relevant papers to the Board of Zoning Appeals. Okay, now we have that, and then we also have the cover sheet that is on, that's this one. You see this? Okay. And this one was received on 6/9, all right? So we have one notice of appeal coming to the board office, or the township office, on May the 30th. Whether you use the date the 16th or the 19th, it falls within the 20 days notice.
Who is it signed by? That's,
Pardon me?
who is it signed by? It has to be signed by a Greek person or official of the township.
It is signed by, I don't know that there's a signature on it. Charles Bennett, ECPO, okay?
That was my point.
Okay. And this one here on the 9th, again, Charles Bennett signing for both boards. Okay. Do we need to go into deliberation on this?
I would think so.
I think
I would-
so, yes.
I would make a motion to go into deliberation.
Okay, let's pause the meeting for deliberation on whether the meeting is legitimate or not.
Yeah.
We shall be back. In deliberation, can you pass these to everybody? It's just extra copies. Yeah, there's a training situation, sure.
What did you want me to pass you?
Sure. So I'm looking at this, the 30th was a Friday.
Okay, it doesn't matter. It's when it hits your computer.
I don't think so. If I can deposit my check in the bank on Saturday,
That.
It's a government entity,
Who
and
did you want me to pass these to?
everybody, whatever.
Oh.
Yeah, that'd be a good idea, Joe, don't argue.
yeah, no, I'm not. Yeah, we kind of found that's what we're trying to say. We don't find those. We do our own thing.
They can all work out. Yes.
Sure. How are you?
Oh, really? So she gets judged by the company. Yeah, well, I mean, she's kind of like an expressive kid, like, she wears what she wants, she, you know, we're just kind of like nerds. And so she talks nerds. She's not, I'm a nerd. Yeah, but she gets judged. But a lot of her friends are, you know, LGBTQ, some of them are non-binary, some of them. Exactly, and so, but they're and she's getting ridiculously, and then she wants to say, friends like to fight, please don't fight. I don't even fight, but fight. Very nice, really. So the two boys left, they did, and so Veronica wanted to speak up for them because she's becoming more like an actress like I am, just like, I'm just done being white. I'm not here, I'm gonna be loud, I'm sorry. You know, and that's like, you know, the week community night. Girl Scouts Township has a really cool activity coming up. We haven't got so much to do, but it's in the function. We're gonna paint together and stuff for businesses. So there's like a flag and stencils. Most of my girls are very artistic. And we did a clear cup. We did a big one, and other my finances were very true. We donated 80 boxes of foods. We did over 440 card Christmas cards for that income. So that's Veronica's got that disabled that activity on that. Yeah, it's we're going from 30 to we're trying for either full or post. Yeah, she's got a color guard. So it is a lot of fun. With Girl Scouts and I do archery and There's a lot of negative things that have been very vocal on that. They play that.
Everybody has really people that
So, even though you did a fine, okay, you opened it on Monday. But still,
We kind of up 100 times.
We're
So
outside.
that's okay. No
We're
problem.
outside enjoying the warm weather.
Yeah, right. Why you never can believe a lawyer, right? Okay, back call to order here. Okay, we did deliberate on whether or not to continue with this meeting or if it is actually a legitimate meeting. Can I hear a motion? And what your motion be?
That paper was in by
Which paper is that?
the appeal by May 30th.
There's a motion on the floor that will accept the May 30th appeal received. Can I hear a second?
I'll second.
Chuck seconds. Any discussion at all? In counting up the days, I count up, counting the 17th, which is actually the day after the actual, what do you call it on this paper? Actual completion date. Okay, that was the day that the certificate was given to the Duns on the 16th. Okay. So counting the next day being 17th, being 24 hours, which is one day, taking that through the 30th or even to the June the 2nd, when because the 30th the township was closed, it comes out to 17 days, which is within the 20 days. Okay. So we have a second. Any further discussion?
You seconded. You seconded.
Yeah, there was a second, yes.
You want to
Well, let's have a roll call.
Dean?
Yes.
Davis?
Yes.
Hall?
Yes.
Christianis?
Yes.
Owens-Seeney?
Yes. Okay, meeting shall continue. Mr. Dodger, are you here?
Yes.
Appreciate your coming. Mr. Dodger was the engineer, the county engineer,
Right.
elected official.
Yeah.
Can I ask you to raise your right hand? I'll swear you on. Do you swear to tell the truth, the whole truth, nothing but the truth? Tell me
Yes.
that.
I do.
Now, we have a, give me a second here, we'll wade through this pile of paper here. We have a notarized, letter here from Matt Rogers, okay? Listing the results of the visit that they had at the property on, what was that, the 16th, was it? The 16th. Were you present there also?
16th of July.
Yeah, you were present.
I was there.
Oh, excellent. Can you kind of give us a brief overview of what you observed?
Well, as part of this, as you stated, an elected official of Erie County,
my role and responsibility is maintenance of drainage, roadways, bridges, within the county, to make sure people get safely to where they need to be. This case was in the office before I showed up at the office, back in January. I assumed the position as county engineer. And on July 16th, we received permission to, go onto the Dunn's property to look at the filling that had been done within the natural drainage course that runs through the property. That, in my opinion, affects the efficiency of the drainage coming through the culvert under, Cherry Road and backing water on the neighbors to the south of Cherry Road because of the elevation of the fill that has been placed in that drainage course. So we will have to do an evaluation of, what was there, what depths that we might be able to determine had been filled, and, the types of material that was in the drainage course itself. So our focus primarily is, trying to work with the township as the engineering advisor for Vermilion Township and all the townships in Erie County, as well as the county commission. You know, part of our charge and duties under the law is to try to provide safe passage and protection of infrastructure and people traveling on our roadways. So, my focus mainly is saying there is fill placed within the drainage course there. It's holding water within the culvert, and at any given time, with a large amount of rain, there is a strong possibility that road will become flooded because the water will back up, because you can't efficiently get away to the north side of the road. So those were our observations on site that day.
So, this dirt that is in number 6 here, you list that, about 190 foot span, you calculate approximately 360 cubic yards, or about 550 tons of dirt, other materials are placed in the water course. Is that, how close to the road is that, would you ballpark? You know, I mean, is it like 100 feet away, 200 feet, or?
Well, just estimating, right now, the fill starts probably, 20 to 25 feet away from the end of the culvert.
Okay,
And then the channel has been filled from that point, proceeding close to a
Okay.
couple hundred feet to the north.
so it's beyond the right of way.
Yes,
Okay, and it's beyond the area that was in contention as far as, getting cleaned out. Never,
well, the initial complaint, as my understanding before I was, within the office, was in 2023, the culvert was completely filled.
okay,
That debris, the county highway department came out, cleared the debris immediately at the end of the culvert. And, so the end of the culvert is open, but it doesn't flow freely because 25 feet away, the channel is filled. So the water has to back up into the culvert, into the properties to the south, to push over top of the fill that is currently placed there. And at times, because of that backflow, the roadway becomes flooded.
Your area of expertise, you're a civil engineer, I assume.
I'm a civil engineer.
Okay, you're the right guy to talk to.
I've been a 1988 graduate of West Virginia University, been working in Ohio since 1989, and private sector, and about 30 years in public sector with Perkins Township, Soil and Water Conservation District, and now the County Engineer's Office.
Okay. I guess the next question is why is the township, looking for an injunction? Why doesn't the county look for the injunction?
Well, the county is looking for an injunction, but we have a responsibility as Mr. Bennett explained, we have a responsibility to maintain the culvert. To make sure that water has a path to go from south to north across the road without impacting the roadway. The township trustees have the responsibility, it is a township road. So the trustees have the legal responsibility to make sure there's safe passage on that roadway. I come in as county engineer because under state law, I'm the engineering advisor not only for the county but also for the townships. So if the townships reach out and say, do you think this is a problem? I would look at it and say, well, with an obstruction just north of the roadway and the possibility of that roadway flooding with the heavy rainfall, I have to say in my engineering judgment, yes, this could pose an issue to the traveling public. So therefore, I guess you could say I'm an interested party in this particular piece of this action.
Mhm.
So,
Do you have many culverts like this as far as they cross the road in a perpendicular across the
many
road?
culverts and bridges in Erie County. We have about 140 bridges, and I really don't know the total count of culverts, but there are many culverts.
Because this one seems to be rather unique.
I don't know how unique it is. It's a passageway for water to go under the roadway, keep the roadway safe.
It's an old one too, I understand.
Right, there are a lot of culverts that were put in many decades ago. Earliest records on this one was probably about 100 years ago.
And would you say that in the 100 years approximation, that things have changed other than elevation? When you think of a water course, you think that there's a channel where the water goes down, as opposed to where there's no channel and the water just spreads all over the place.
Right.
Is there any notice of that situation?
It depends on the location. At this location, it appears that there's been some, looking at aerial photographs from the 1930s to present, it appears that there is a water course that flowed through agricultural ground. Of course, that agricultural ground now has been developed over the last 100 years. As people build but the natural flow of the water is still following the same elevation path that it probably has for centuries. There may have been some adjustments here and there as houses were built, but it's still a south to north progression toward Lake Erie because that's the ultimate outlet for water in Erie County.
Chuck, any questions?
No.
Steve? No. Larry?
No, I think not.
No. I don't have any other further questions either. Thank you for your time. Appreciate your taking time to come and talk to us.
Thank you.
Mr. Chairman, may I ask you some questions?
Yes, you may. Yes, you may.
So, did you determine who was the owner of that culvert pipe?
Well, it's part of the public infrastructure.
Whose public infrastructure?
It's the Erie County residents, it's a piece of infrastructure to provide safe passage on the roadway to allow water to cross under the roadway.
Who constructed it, do you know?
I don't know that.
Is there any easement that you know of that allows that water to flow onto the dump property?
There's no formal easement that we're aware of.
What watershed is in dump property, do you know that?
I think it's Sugar Creek ultimately that it flows into.
No, Darby.
Darby
Creek.
Darby Creek flows to the north.
Have you done any hydrology studies of the drainage that flows from the south to the north?
No specific studies.
Do you know where the source of the water is that's being dumped on the dump property?
Objection.
This is
Do you know what the source of that water is?
Water is natural land, the water flows from north or south to north through that area.
Do you know where that water is coming from?
My office has developed a watershed map that shows the general area where water will flow.
Well, let me ask it a different way, realizing that you're under oath. Do you know whether or not any of the water that's coming out to that property has been diverted from land to the south of the property?
No, I'm not aware of it.
Have you done any kind of studies to determine whether that in fact has happened?
Not anything specific.
Did you walk the Dunn property when you were out there?
Yes, I did.
From the southern boundary all the way to the northern boundary?
I walked from the southern boundary to the 12-acre field in the bottom land. I did not go to the northern boundary.
And would you characterize, what did you see there? Did you see a ditch?
I saw a ditch at the roadway through the ravine into the bottom land.
Was that a man-made ditch?
I have no way of knowing.
Is it the county's ditch?
No, it is not the county's ditch.
Do you know whether the county has a duty and responsibility to maintain that ditch?
We do not have the responsibility because it's never been a petitioned ditch maintenance project.
Well, if there's water that's flowing from the south through a culvert, which you say is part of the public infrastructure, into their ditch, why wouldn't you have to maintain it? Just asking that question.
Because my understanding is under the Ohio Revised Code, that ditch would not be on maintenance. It's part of private property ownership. And unless we are specifically requested by petition to make improvements to these drainage courses, where we can't go on a piece of property to maintain a private ditch,
Is it
private water course.
Is it your testimony here this evening that the county can allow water to be diverted from the south onto the Dunn's property, and yet you have no responsibility for what course
No,
that's
I'm not
point
saying.
out?
I'm not stating.
Just a few more.
Can I ask one question?
He has an attorney or other.
Your representative is here to.
So, at the bottom of the ravine that you just mentioned, from there to my farm field, is there a ditch? And you walked it, is there a ditch?
Once it gets to the bottom of the hill and the land flattens out, the ditch ceases to exist.
So there is no ditch at all on the bottom of my property?
There is a water course that carries water.
There's no ditch.
But there is no specific.
So you're dumping water on my property?
Your Honor, I'm not going
to.
to have this. He's not going to attack this witness. There's not been a testimony. There is no dumping. Any evidence in this case?
All due respect, Mr. Bennett, you're not the arbitrator here. I understand that you have an objection. I just have a couple of questions. Have you made any determination as to whether or not the Dunns have the right to use their property for agricultural purposes?
That's not in my purview.
And you don't have an opinion whether they have any legal authority or a right to maintain their property and to improve their drainage for agricultural purposes?
That's up to the private landowner. It's outside my jurisdiction.
And if they have an agreement with the federal government to maintain their property and to provide drainage so that they can use their property for agricultural purposes, you wouldn't have any problem with that.
That's outside my purview again.
I don't think you would.
Okay, thank you. Any other questions? Mr. Bennett, do you have any questions?
No, Your Honor, I would ask that this witness be excused.
Okay. Thank you for your time, Scott.
Thank you.
Okay. Any questions from the board here at all? Any further discussion?
One word is the appropriate time or not, but the reason I asked for that, I've got more papers here now. That document 7, which is it makes mention of the, in the letter from, and I have to say, you know, I'm in these programs too, and I know all these people. So it says, among other things, that included in this packet is a conservation plan and conservation plan map. Yet I don't see any map in here.
It's a huge folder, if you know.
Yeah, I know.
And what you also notice is that Mr. Dodrell just said that it's Darby Creek watershed that he's claiming flows on my property. The U.S. Department of Agriculture has stipulated that I'm a non-wetland property. And if you look on the second page on the top, the watershed from my property, that the Department of Agriculture, which is federal jurisdiction, determined it was Sugar Creek, not Darby Creek. So in 1996, the Erie County Engineer's office did an illegal ditch project where they rerouted and redirected all of the stormwater from over 400 acres onto my property. That's the problem. That's why Mr. Dodrell just testified that there's no ditch or waterway actually on my property.
Thank you for that. But my question is, I'm looking for this conservation plan map that's spoken of here.
We can provide it.
I have it right here. There's nothing on it. The facts are the facts. Eventually it's gonna come out. Then it's gonna be talk.
I'm sorry, sir, did you mention me?
I did.
What can I do for you?
Okay, guys. For application.
Because you counted 100 times, and it didn't come up 17 back. I didn't see that document, because I don't have.
But if you don't have it,
No, I have it,
Right
sir.
there.
Right here.
That's why I asked you if you received on, certain. You and I talked about that one already too.
Same conversation.
I remember I can-
You know what I mean?
I know exactly.
We did.
So all the woods are in the EQIP program.
Has he been sworn in, Your Honor?
No.
Has he been sworn in?
No.
Is he giving testimony?
Actual.
Looks like.
This is the application.
All right.
This is the.
He was asked for information, so he's not testifying to anything. Yeah.
That's the application, that's the data.
Yeah, but that's,
This is just an email.
no, this is an application. That is an application. Okay. Oh, here's exhibit 7, defendant's exhibit 7. Okay, any other questions? I have one question. The last meeting, we talked about, there's, the next court hearing is what, on Friday, the 15th, is that still a thing?
Court dates have all been vacated, Your Honor, because the Duns have employed the attorney before us, Mr. O'Toole. And since Mr. O'Toole has just gotten into the case with his partner, Mr. O'Reilly, all the court dates have been vacated, and I'm not even think we're getting in front of the judge now until November.
Okay. All right, my next question is that, can you explain how the fact that a certificate of compliance was issued, how that will affect the court, the next court case?
Well, I'm going to argue strongly that it has no effect on it because the Court of Appeals have already upheld Mixer's Sexton citation. But the reason I came to this court is because I don't want to have dueling citations, one that says he's done everything just fine and another one that says he's in violation before this judge. This judge is hearing the case from Cuyahoga County. He doesn't know the lay of the land in Vermilion Township, and that's why we're resorting to all these witnesses that we have.
See, what I'm seeing though, is that Keith Sexton's citation dealt with the pile of stuff at the culvert pipe, okay? That has been since removed.
I think I can answer.
And there is still non-compliance from the court's action.
Right, what the court said back in April of 2024 with respect to the citation. And if anybody wants to look at this, this is the judgment entry exhibit that we have. It's about 7 pages long, and we go to the last page. And what the court held was that under Part E, and that's the final page, page 6, you are to be in compliance with zoning code 2223, prohibiting them from engaging in this type of excavation without first obtaining a permit from the engineer. Part F, the court held, be in compliance with 2211A, prohibiting them from engaging in this type of excavation which unnaturally diverts, blocks, or interferes with the natural water course that we took evidence of in April. So that is what the court ordered the Duns to do. What Mr. Baxter's citation is essentially saying is, you're fine. And that is the reason we are aggrieved. That is the reason we are here, is because the Erie County Court of Common Pleas has ruled that these parts of your code must be complied with. The Duns timely appealed that to Toledo, the 6th District Court of Appeals, which upheld that. That is the reason that we're here, Your Honor. I'm aggrieved by this citation, as are both boards, because we need clarification. I don't want to walk into court in November or whenever it is with 2 different citations to have the court decide which one is in effect. I will argue strongly if we lose tonight, and if we lose, we lose, but I will strongly that it will have no effect on what the court does. Thank you.
Anybody else have anything?
Yeah, I got something.
Sure.
Doesn't Judge Bennett's order say that the creek has to be, stream, whatever you want to call it, have to be returned to his previous state?
Yes, it does.
2023?
It does, sir. It does.
At the culvert or throughout?
Throughout. Let me get the opinion. What the court held with respect to your question, Mr. Hall. Unblock, clear, remove, and reverse all dirt, debris, etc. They are responsible for being placed into or in front of culvert V212. The next one, unblock, clear, remove, etc. The rocks and debris, they are responsible for being placed situated in the right of way. And finally, most important, C, unblock, clear, remove, or reverse all dirt, rocks, and debris, which comprise a large mound of dirt that they are responsible for erecting, which diverts property from their own property just north of the right of way. So the court went further and said, even though it's outside the right of way, we are going to ask you to remove it for one reason. There's a statute that we sued under, or that we filed the injunction under, called 558906, which forbids the Duns from blocking any ditch, drain, or water course. We had no jurisdiction until the road started flooding. When that happened, we sent out warnings. We tried to work it out. We just had a disagreement, because the disagreement at the center of this case is the word dumping. We are dumping nothing onto Mr. Dunn's property. Water goes downhill. And that is what the affidavit of Matt Rogers, the engineer, he took 90 different elevation levels. He saw that it lowers itself from V212 to the culvert up on Thompson by 70, I think it was 77 feet. We're just going downhill because water goes down to the Lake Erie. It goes down to the sea. Thank you.
And just as a point, we're talking about Darby Creek and Sugar Creek. I don't see how you can flow to Sugar Creek, because Sugar Creek runs through my property, and I'm on Barnes Road, which is like 2 roads over. The whole different watershed, because I think it was brought up that, well, why don't they just drain that culvert over to Risden Road, and they couldn't do it because it was a different watershed. So, I don't know that Sugar Creek is the correct creek. I mean, I'm just throwing this out.
Well, those are the federal, and that was a determination that's.
You can't believe the federal government, come on.
Well, it's.
They want us to believe that.
I mean, that's, there's, one of the problems that again, I hope it doesn't become an issue here, but it does maintain and how maintain that there has been a diversion of water onto the property. And it's not just the natural flow, it's the acceleration and diversion onto the property. And you know what that means? It means it's a taking of property without just compensation. Now, someone's going to be responsible for that, whether it's the township or the county or someone, but that water is being diverted. But again, this is like a shiny object over here. I want to just go back, I don't want to rehash what we've done, but what's in front of you is your zoning administrator already determined that there's not a violation. All of these pictures of the flooding, you guys know, man, that there's flooding on Joppa Road, that there's flooding in Vermilion Country Club, and all over you have those events. That's just not before you. What's before you is, did the zoning administrator have the authority to do what he did? And the reason why one of the very first things I brought up in Exhibit 2 is what his duties and responsibilities are. And he's ruled that there's no violation. That's what's before this court. If you rule that, and neither Mr. Bennett nor the township nor Erie County have the right to bring an appeal to the BZA. They just don't. I mean, that's the threshold issue in this case. I mean, we could talk about the water sources and all of that until midnight and come back tomorrow and do the same thing. But that's not what your job is here. Your focus should be on what's in front of us. What did the zoning inspector say, and who appealed that? Well, the aggrieved party didn't appeal it, and I respect Mr. Bennett's position on behalf of his client, but he personally is not the aggrieved party. He might have a vendetta against the Duns, I don't know, but he's not an aggrieved party. The township can't be an aggrieved party, and the county commissioner certainly cannot be an aggrieved party. That's what that litigation is all about. Why you're entangled in this litigation, or want to be, is beyond me. Why you want to get, that's like wrestling with a tar baby. You're going to be in court for the next 5 years, Lord.
I don't think anybody wants to be here.
Nor should you be.
I don't think anybody wants to be here. However, if we have a job to do, we're going to go and deliberate. There's going to be, whatever our deliberation determines the outcome, there's going to be a winner and a loser, so to speak. I think everybody loses in this case. I really do. If whoever doesn't come out on top has disagreement, they can always appeal to the common pleas court for our decision, and that's just standard knowledge for a BZA activity. So let's go pause the meeting again. We'll go.
May we be then just excused and
Yeah, if anybody wants to leave, absolutely no problem. I mean,
you don't require our presence back here, you'll
no, I really
or
don't.
something.
Yeah, we really don't. What we'll do is we'll come back and we'll give our determination, motion, votes, and so forth. You will be notified.
Sure.
And everything is public record, so
Okay.
we'll go from there, okay?
Thank you for your attention.
Okay,
Appreciate it very much.
Thank you for coming in, appreciate it. No, just pause the meeting and off we go.
Okay.
So we will be back and might be a while, might not be. You're gonna do what? Oh, come on, Joe. Dude,
Should we wear order?
Sure. A long day, Joe.
I'll walk up and see not holding anything else. My kids are experts at that.
That's what I had to go to my grandkids to find out all that technical stuff.
Yeah, right?
So,
Those are the ones that show me how to
I
do
heard
it.
really exciting stuff.
Yeah.
Just let everybody know the camera is still live,
Nowhere else.
just so that we can't say that there was any manipulation of the video. Please, thank you. Hey, what's up?
Teresa, how's her knee doing?
It's a little better today.
She gotta go to the doctor and take a look.
She says she needs to, it's a different need that she operated on.
Yeah, she was saying that. They gotta get that right.
And I gotta get it.
I'm telling you, I'm thinking of this.
She's talking about doctor gave her. Yeah.
Some of my points are valid.
Right, you think it's hot in here?
It's a little warm,
I turned it down. It was up at 78. It like switched.
was?
Yeah, cranked it down to 72.
I knew Galaxy.
I know, I did on purpose. I was ready to hit it like 64 just to chill everybody out so everybody goes home.
Yeah.
Gary,
I guess so.
how are you doing there?
That's where we got the six. Then I go to my sister-in-law's house 75 feet away from mine. First thing I
A
ever
lot of
did.
information. Too much.
How are you doing?
I'm well, and yourself?
I am living the dream.
That is a very skewed dream. Oh my goodness.
Yeah. I didn't think it'd last this long.
I was kind of hoping they said, okay, we're going.
We'll continue next.
Yeah, no. I can't take it anymore.
I don't understand the people whose properties are flooded. Right. You know, we're on the other side of the Dunn property. And, what's that, other side of the road? We're on Darrell Road. Okay. Our property's run, I run past Stivoli's and we run down the hill. Yeah.
Mr. Stivall is a
Oh, God, I'm
Well,
always
they-
taking care of that old guy.
how old is he now? 80 something?
No, he's gotta be 84, because he was 83 last year.
I know Mr. Stivoli all the way back to Berea days. Actually,
You play baseball?
I did. Yeah, that's how I know. And actually, my father even knew Mr. Stivoli from Berea,
And
and
Mr. Stivoli's life has been baseball.
he loves it. Every time I haven't seen him in a long time. I always call him
I
boss
see-
man.
I always see him and, you know,
He's a lovely individual.
he's a really good neighbor, and, you know, his granddaughter's cattle jumped through a screen or something, he'll fix it. You know, and he's got a gas well, right away in a gas well on his property that's next to mine. And I built a little shed that over it that can be disassembled, so when they wanna clean out the pipes,
Yeah.
we disassemble it, they clean out the pipes, and then one of my kids come help me, we put it back, because, you know, poor Mr. Stoley.
No.
No.
Last time I saw him, he was still driving for Pat O'Brien.
That's over with.
That's long since over with, yes.
You know, and it's just mainly him and Mrs. Scavoli, and the granddaughter lives with him.
Yeah, Erin pops in every now and then.
She's a wonderful young lady.
She is a lovely girl.
I guess she's the animal queen.
That's what I've
Got
been
turtles
told.
and lizards
Yeah,
and all kinds of stuff.
I can do without the lizards, but,
But you know, he's been a very good neighbor for all these years.
he's a wonderful. Yeah, Mrs. Stavoli, just charming.
But you know, our whole neighborhood, it's unfortunately changed because my wife married a younger ones now. And, you know, we've had a great neighborhood all the time.
So where about on there?
I guess heading east from Cherry, there's a couple of houses, a field, and there's a white colonial.
Yeah.
A white colonial, and there's another, single story.
I'm waiting for him to say, I'm none of those.
And then there's an empty field, and then there's two more houses, and both of them were blue. I had to build them, and I couldn't believe that both people wanted blue houses. Wanted both their kitchen, mother and daughter wanted the kitchen that looked like a cow.
I know exactly what, they're ones that had the sidewalk that went in between houses.
Yes.
No, it's further down.
Oh, further, all right, I go, oh, yes, I know where you're at.
The sidewalk's gone.
Then they moved from there, and they moved over by, the store in Axtell.
Yes.
And if you look across, you see a great big white fenced in yard.
Yes.
Yeah. All the monster houses that could all live together. And grandma died, and then the kids moved into a development where, they lived, and both their children lived in the same neighborhood, all close together. Look at when I was doing that, they say, they go ahead, do the next.
Did you build those two houses?
I only built one. The other house he had, saved money, had Wayne House
Wayne.
build it.
Wayne, yeah.
Wayne those are decent. You know, the structure is decent, you know.
They don't build by city standards. And that's why he was digging up his house 4 years later, because water was coming. It takes more than a truckload of stone, and water.
Oh.
Two letters.
The stuff that they do, like, they put dirt in there without.
But you know, I see it.
That's a big neighborhood, man. And then a year or so later, they went by the driveway.
Catalogs.
So how I originally.
Yeah. All right, drive safe.
Yeah, we worked on houses for Avon Lake. That's mainly where we work. Avon Lake Village is not the river, except to build homes out here. And these big developments in Bucky Fowl. 4 years
Oh,
later,
Bucky.
4 years later, the entire slab part of the house, of this $500,000 house sinks.
Yep.
And then we have to go in and pump up the floor with foam. And then we all the trees. Yeah, you sand or mud.
Yeah.
What happened?
It just blew in air.
But you know what? The only thing I can say about the maps, is that Avon Lake is, the home values are like incredibly high.
They are.
And we've also built Sheffield Lakes, and you can hodgepodge everywhere. You know, and Avon Lake they stuck to keep the homes nicer, and
They did, they stuck to the format, but it's also very difficult to build in.
it was. We were scattered lot, so we built one house.
Yeah.
Because otherwise you wouldn't now.
Did you build for yourself or did you build for?
We just built our homes.
Yeah.
Let's try and build places like across from here. The people who live across the street.
That was the true stuff.
And so they go away.
It's amazing.
Yeah.
Yeah, over there was Portland. Yeah.
And Walker Road was crushed stone. It was.
It's not clear, right?
Yeah.
Yes. Of course not.
I grew up in Avon. It's crazy. 83 was like, you know.
Put it like this.
Oh, yeah.
And when we were kids, we would have our shotguns and our planes go to rabbit hunting. We'd be hitchhiking, and somebody pick all three of us little kids up with our shotguns, take them somewhere to where we legally hunt, and we'd hunt all day and come back. If we wanted to water, you just knocked on the door, and the lady would say,
And where did you
oh yeah,
grow
drink
up?
out of that garden, on Vineyard and Avon Lake.
On Vineyard, yeah, I grew up on Flood Road.
Okay.
And so
Same
you,
thing.
and you know, it's one of those things where got cut or stuff.
Not my fault. It's not. I loved it though. Yeah, I went to town. Loved it. My whole family's from over at 21st Street, next to the park. Those are the kids I grew up with. I learned how to throw rocks. There was a lot of projects. So, you recognize the school system. Yeah. Yeah, it was, you know, when I was a little kid, their name was like, you hang out and go to great. I love it. My name's Paul Seaton. This is my wife, Karen Brown. Paul Seaton.
Very nice to meet you. Like the last meeting, you got a cousin getting off.
Yeah, we were, yeah, like tonight I got Vermilion fishing game. Oh,
Really fun.
you know what, all that's left are a bunch of old guys, there's 600
You
and
know
some
what I'm
members.
actually on?
It's so shady.
See, what they do is they- Yes, yeah, yeah.
Sounds better.
I was using it. Yeah. He moved somewhere else. Yeah. And he's already heard,
Yes.
okay, I'm sportsman's dad. Okay, yes. Because, you know, and that's how I got into marine fishing. Because I met Don.
Now, how long have you guys lived here?
30 years.
30 years? And you're on there, so you're not too far from us. They're not, she's you're calling. I'm up in South Park, BFW or Banks.
Oh, yeah.
That's where you are. I'm over there, so. I used to be the only one over there, now I got neighbors, so I freaking hate it.
Yeah, I joined the BFW so I can fly fish from steel. In fact,
Oh, where's your pal?
you know,
You know, you really have to join.
in fact, Dick, it was Dick and Darren was president, and he goes, Cedar? Because he used to dig my basement. And he goes, Cedar, he goes, you're the only person who's ever come here to join the BFW with waiters.
Yeah.
I said, well, I want to go
Walk
fishing
down the
now.
hill, right?
We built,
So you knew like you knew like Sharapa.
yes. Oh, Jim used to dig for us. He used to dig for us. The guy can pick up a quarter. So we're working in the house. We're working in town, digging around the house to lift up, put a new basement. And he goes home for lunch, and I call the breakfast. He goes, oh, Gene will be back tomorrow. He's taking a nap. He left me about 90. He was still digging stuff for me in his 80s. You do insurance.
I told yeah, why not sit up there? It's like, I graduated in third grade. Don't you record that.
Is that
I can't listen to something.
We know nothing. We're just on the receiving end of their water.
Yeah.
Actually, a lot of them are trying to help you guys.
Everybody else is talking.
And this is where the fees can be structured. Toiletries, water, also, this is the last meeting, this meeting, this cost.
I'm sorry. Oh, so you were in it's a lot of water itself. I think that you were actually discussing trying to find a window. So, yeah, it should be, I can't do that while you're here. Larry, son, you why is that Sweetheart, do you know any people that work with that's the deal?
Are you Larry's wife? Oh, I'm Stephanie. Nice to meet you. Yeah, there was. Your son, Larry, would have been my great. Yes. Okay. Where to?
Now they're on Cherry.
Okay. Okay.
That's a small one. Yes.
My youngest son, Chris, chose to go to fire.
You were on the tractor day.
Who doesn't want highway?
Who would get you? You wanted a tractor. You know what? They've been honors since 77.
Larry's down in, he's just so busy, okay. I know. Should be sitting here. Right, does he like it? Yeah. And so, do you have grandkids?
Oh, my.
Four, okay.
We have to let her know it's stuff.
You might remember help with that. No, my dad, Erie County Bank, side bank. My dad, and my mom was Judy. Yeah. Most of the time. No. There was that, yeah. I have she worked for
That's their argument. They won't have much money. It's changing. It's very compliant. If it's 2 out of 3 months,
Oh my goodness. It's insane.
Before you lived in it, you used to have 1,300 square miles. And they had
They're so dumb. This is not a summer town. It's like that every day of the year. I'm like,
well, the big thing down there is like 85 plus. Like we're in North Carolina. It's 85 degrees. You're walking down the street, enjoying the beautiful weather. Yeah. It's 29 degrees down there.
no, but it was just not.
Oh, yeah. But it's a ghost town. Nobody's on the road. And I have to you can't make a good donut. Are you familiar with them? Still been in for? It's so crowded. Oh my goodness, it's so Oh yeah. About 3 weeks today.
oh, really?
I really did, yeah.
Oh, come on.
Two little tiny incisions, the blue snipped
Yeah. Snipped here, snipping here, snipping here, get the cyst. I have not even had to have one painful. I actually got out of the bed and walked around the wheelchair. Yeah, it's felt like 2 months. Damn right.
Dr. George is the man. He got your arthritis. You have to keep up.
See, now this group understands what something like when we go to executive session. I know.
That's why you know it.
Yes.
And you should come in when you're ready. Okay, we're done.
Which we did last time.
You know,
live down here.
I know. They're not supposed to be able to.
I know. Yeah, I know. Just like Chris. Yeah, when I kneeled on this a couple of times, it told me really bad idea. Really bad idea. And I got up and it took at least almost a good minute for me to stop. So, and I think that's because the stitches that are inside hadn't dissolved yet. So those little pokey little sons of guns were telling me, you're an idiot. And it was right.
Is it still numb? Like, can you?
No, dude, I feel amazing. I mean, absolutely amazing. I know I can't run here during the end of the day. I did one stupid day where I was doing some retention basins. So it was like 3 hours of 45 minutes. And then I had to use it. The only thing I've had to do since I've had this ibuprofen. Oh, I did it one time. Just I'll tell you what, Dr. George, praise that man enough. Stuff he does, you can't really. It's amazing. I actually have a very challenging job. I actually so I'm prior to it, so I was already pretty well. That helped a lot. But yeah, it was very nice.
We can go see a neurologist that did cognitive testing for brain injuries, and she was tested for 4 hours. It was a long day. But the good news is, we went back to get the results, so she was taking no difference. Like some of the things, amazing.
Cherry, no time. Oh, Cherry. I mean, she may be, are you on the east side or the west side?
Are you on the
You're welcome to see her. Yeah, that's the problem.
It just shocks me that how do you like have so fracture I mean, whether they said it's getting better every time you do it, it's getting better, and they said okay, we're good. So she got released.
It's like contraction, everything kind of done, that side of I don't know. Maybe from the farm, I see that. Yeah, it's a little.
I was consumer of tea sisters, but I don't think it was right.
We're coming back, guys.
We're not they're all adults.
Right, it still counts. It still counts.
Yeah.
What's that? Oh, wait. Set up.
Okay. Back in order. Okay, we've gone through deliberation. A lot to talk about. Can we have a motion?
The motion, is to rescind the certificate of compliance issued by Mr. Baxter and grant the appeal to Mr. Bennett and the boards.
Can you read why?
Yes, I can. The law of the case doctrine provides that the decision of a reviewing court remains the law of that case on legal questions involved for all subsequent proceedings in the case at both the trial and the reviewing level. The citation issued by Keith Sexton was found valid and enforceable by the 6th District Court and the Ohio Supreme Court. The 6th District Court of Appeals held that the Common Pleas Court judgment of April the 18th, 2024 is affirmed. Therefore, the Vermilion Township zoning inspector had no jurisdiction to issue the certificate of compliance. The Duns claimed exemption of the township regulation under ORC 303.21A and 519.21A, stating they were agricultural, but failed to appeal the Sexton citation to the Board of Zoning Appeals. Therefore, they failed to exhaust their rights under the administrative appeal process. Based on the expressed facts in this hearing and facts determined to be true through the courts, I move to rescind the certificate of compliance issued on May the 16th, 2025, and to grant the appeal to Mr. Bennett and the boards.
Would be any discussion? Everything to say? Steve?
No.
Larry?
No.
Can we have a second?
Second.
Chuck seconds?
Dean,
Yes.
Davis,
I'm gonna say no.
Hall,
Yes.
Christianis,
Yes.
Delancini,
Yes.
motion passed.
Motion passed, 4-1, okay? Just as a side note, they were right where this didn't belong here. This belongs in a court. Definitely belongs in a court. It is way above our head, to resolve this matter. We have two parties that, we can see both sides, we really can. And to get it back into court, that's where it belongs. And that's what we understand too, and we wish everybody the best, we really do, but, it really wasn't ours, okay? Okay, thank you. Oh, wait, can I have a motion to adjourn?
Yeah.
Steve?
I second
To
that.
adjourn, second by Ms. Cole?
Dean,
Yes.
Davis,
Yes.
Hall,
Yes.
Christianis.
Yes.
Delancini,
Yes.
meeting adjourned.